So, Mr. President, given that reality, I have some serious concern with some of the regulations. Firstly, let me deal with the tribunal. It strikes me that the appeal tribunal is kind of restrictive. Short time for which appeal must be made. When you take that, for example, compare with the process for judicial review, you have at least 3 months. But this strikes me as being too restrictive. Secondly, in terms of the appeal tribunal, you are giving them power to award costs. The general view for challenging the state has been that if you go, say, via judicial review, cost is usually not awarded against you. Sometimes it is, under certain circumstances. But now when you introduce costs against the little man who may challenge, it kind of tell him, brethren, don't challenge Whitehall. It may be costly to you. Don't challenge the government. Matthew is from London. Don't challenge the government. It may lead to a cost against you. So, Minister, may I ask you and the authorities to review that and to make sure people who are bringing challenges are not inhibited by the fact that costs may be awarded against them. So I urge you, we can't change it today, but I urge you to quickly make that change so people feel free to challenge. Now, I'm not encouraging frivolous and vexatious challenges, but people may have a reason to challenge and treat it in the way judicial reviews are treated, where you lose is not necessarily against you. And the tribunal issue, Minister, it's not very clear to me whether the tribunal can award compensation. But if it can, I'd recommend that, especially if somebody would be able to challenge where a minister said nothing private and secret anymore, and compensation is awarded, that the tribunal should be able to attach interest to such an award for compensation. Because I think it's long past time when we should give tribunals, by law, the power to award interest. I think Senator Brownn would say the Law Reform Miscellaneous Act was passed, President, in 1955, giving the Supreme Court the power to award interest. That's 69 years ago. I'm not sure if our parish court judges have that power. Some arbitrators may have the power, but time comes for these quasi-judicial bodies to be given the power to award interest where compensation is awarded. And I make a reason for this, President. It doesn't escape me that in Jamaica, there are tribunals who are not given that power to make an award of interest. But say somebody was terminated in 2013 and got an award soon thereafter from a tribunal. And lawyers as bright as Senator Brown is, let me withdraw that. Not as bright as Senator Brown is. Run it through the Supreme Court. Loses at the Supreme Court. Run it through the Court of Appeal. Loses there. Take it to the Privy Council. That is why I made the changes and said not as bright as Senator. No. I don't want to do that. But the point I'm making is that such unfairness in the system, without a tribunal like this being allowed to award interest, such a worker receives an award, but is not able to get the benefit of the time value of money. And I'm sure Senator Gill would support me in saying, time for us to review these tribunals and give to them the power to award interest, so that those who are not so bright as Senator Motley, Scott-Motley, may not wish to tie up these awards through judicial process and through the judiciary, which can take a long, long time. And so I make that plea. You and I can talk about Manchester United. Forget the rest of the issues. Mr. President, in the service agreement regulation, it speaks to the express consent. And I believe, Minister, it's good that we tie it down that the express consent of the individual must be obtained. If you listen, you will understand the point I'm supporting her. No. I forgive you. You know not of what you speak. You know not of what. Minister, it's good to insist on the express thing. I see the authority says they will stipulate the form. He hasn't read the regulation, so forgive him. They will stipulate, but you still haven't read it. They will stipulate the format of that consent. One thing that worries me is that bright lawyers do exist, and they will find ways to go around what is stipulated. So what I'd like to ask is that the express concern must be in a standalone form, whether it is a manual form or an electronic form. It must be a standalone form. So it's not tied into getting the job. It's not tied into getting the loan. But people must be free, really free, to decide, I am consenting for you to get my information. Otherwise, what the bright lawyers will do is simply tie it into something that you really need. I need a job, so I sign for the job and the job letter, and tie in with that is this express consent form. So I'm asking that the express consent form must be attached in any way to any promise or any other condition, and that the person, the individual giving that consent, must be seen to do so freely and unencumbered by any other requirement. So I make that plea, hoping that it is something that your authority can look at. Because as I say, lawyers who are brighter than Senator Hill, far, far brighter than Senator Hill. It may not be, but who are far brighter than Senator Hill will find ways and means to trap people into, sorry? Yeah, trap them into consenting. Well, take it. I'm free. I'll sit down and let the president rule. But there are, so I repeat, they will trap the individuals. Yes, trap, that's what I said. Trap, no, we don't. We may trap employers who are doing wrongs. That is, we catch you. We catch you, you know nothing about Kodia, so shut your mouth. You know nothing, I withdraw the shut your mouth, but you know nothing about Kodia. You know nothing about it.
Hello, please. Let me explain. Sorry,
point.
Senator Brown. I have some visitors here. I'm going to invite them to join me for lunch. Time is running. Do not interrupt the speaker, please.
So I make the point, Minister, that it is important that the express consent be separate from all other things, so we protect our people. So, Mr. President, I close with the big concern I have. There is everything that is no longer private and secret. We must respect the privacy rights given in the Constitution to our people. Our position in government, in the state, ought not to be abused. And I say this in respect to all sides. I certainly was never happy when I read on Twitter X that my friend Senator Samuda was British. I certainly was not happy when I read that other members of the Senate have dual citizenship. I certainly was not happy when I saw the passport page of a minister of government with a certain notation by the US State Department, and people interpret that to mean drug trafficking or money laundering. I was not happy with that. I was not happy with that. So my call is to respect privacy, respect secrets. My call is to respect the Data Protection Act. My call is to get the confidence of the people by being honest with them, by stop playing politics and being expedients on any side. And that is why my columns in the Gleaner have always been for principle over expediency. And Minister, Mr. President, at my age and stage and experience, I'm happy for them to talk, because the people can see for themselves that what I am saying is like throwing stone in a pen. It's like throwing stone in a pen. So, Mr. President, I beseech all and sundry to respect the privacy rights of our citizens. Stop being expedient. It gets us nowhere. What it does is expose all the hypocrites who exist in the society. As Bob Marley said, see the hypocrites that are go along there. Thank you, Mr. President.
Loyal viewers and subscribers, honorable people, give thanks for your support to the AVI-NUE. Know that I appreciate you sincerely. New viewers, welcome on board. Know that your presence is appreciated. Please subscribe to the channel and help us reach 1,000 subscribers. Thank you. United we win.